Contract essentials. An agent must have a working knowledge of contract law because every aspect of the business deals with the contract. A contract is an oral or written agreement to do or not to do a certain thing. The essentials of a valid contract are capable parties, lawful object, consideration, and offer and acceptance. To be a capable party, the person must have the legal capacity to contract. Typically, this means the person must be at least 18 years old and of sound mind. Other competent parties would include the person given authority to enter into contracts on behalf of a corporation, a person with a proper power of attorney, a fiduciary given the authority to contract, or an emancipated minor. A contract must be entered into for a legal purpose. For example, when you see in the movies a contract to kill, that is really no contract at all because it is not lawful. A contract like this with an illegal purpose is void. A contract must also be entered into freely without duress, threats, blackmail, misrepresentation, or fraud. Consideration is anything of value. It is bargained for and received. Valuable consideration is something of value given or promised by one party in exchange for the promise of the other. Valuable consideration is usually the promise to pay money in exchange for an item that has monetary value. Offer and acceptance is also called mutual consent or a meeting of the minds. An offer must contain the exact terms and conditions, and the offer must be accepted without changes. The offer must be clear in character, the property must be accurately described to identify the subject matter, and you must have an exact price. You cannot offer to buy a house for a whole lot of money. You must say $1 million or the exact amount you are offering. The offeror is the party giving the offer, and the offeree is the party receiving the offer. In real estate, the offer is usually made by the buyer and received by the seller. An offer must be accepted without change by the offeree or the offeree's authorized agent. Prior to acceptance, an offer or counteroffer can be revoked. Notice of revocation must be received by the offeree prior to the acceptance of the offer. An offer will be terminated by death or insanity of the offerer or offeree, destruction of the property, or a material change in circumstance. A counteroffer occurs when the seller changes any of the terms made by the offerer. This reverses the legal position of the parties as the offerer becomes the offeree and the offeree becomes the offerer. Many oral contracts are valid and enforceable. However, most contracts involving real estate must be in writing to be enforceable. The statute of frauds determines the documents that must be in writing to be enforceable. In most states, real estate documents such as sale contracts, deeds, and mortgages must be in writing. Some states allow an oral listing for less than 1 year, but in order to be compensated, a brokerage firm needs an employment contract in writing to collect compensation. Therefore, it is in an agent's best financial interest to have a written listing agreement. Many real estate contracts contain a time for performance. For example, a listing contract contains an expiration date. An offer contains a time period. And a sales contract contains a date at which the buyers must inspect the property and secure a mortgage commitment and a closing date. In the case where a time period is not specified, the law will give a reasonable time to complete the contract. When the phrase "time is of the essence" is written in the contract, it means that everything must be done within a specific time. If the requirement is not met, the promisor will be held to have breached the contract, and the rescission by the promisee would be justified. An as-is clause in a contract means the buyer is buying the property as he sees it, with all existing conditions. The seller is still bound to disclose property defects, but not to make repairs. An assignment is the transfer of contract rights from one party to another. This could be the transfer of a right, title, or interest in a property. A contract is assignable unless the contract or state law forbids it. Personal service contracts are usually not assignable. The party transferring the contract is called the assigner. The party receiving the transferring contract is called the assignee. For example, 2 years ago you entered into a 5-year lease agreement and opened your business. Today, a party wants to buy your business. If you sell your business and assignment is permitted, you may assign your lease to the new owner. If the lease is assigned, you are the assigner and the new owner is the assignee. The landlord would now expect the lease payment from the new owner. An assignment does not relieve the assigner from liability unless novation has been granted. Novation is the substitution of one contract for another and releases liability. Just remember, nova is Latin for new, hence novation, a new contract. A liquidated damage clause is a contractual provision that determines in advance the measure of damages if a party breaches the agreement. In a sales contract, the earnest money may be considered liquidated damages if the parties so agree. That is, if the buyer breaches the agreement, the seller may keep the earnest money. Specific performance is court action to force the completion of a contract. For example, if all the requirements of a contract have been met and the seller refuses to sell the property, the buyer may sue for specific performance. Brokers do not sue for specific performance. The rescission of a contract occurs when there is an agreement between the contracting parties to waive all the remaining duties and to terminate the contract. In essence, it would be returning the parties to the same legal position they were in before entering into the contract. This concludes the section on contract essentials.